issued by ICC, and it's an instruction for banks how to examine documents presented for payment of minimum letter of credit. And Article A3 states, quote, if document is the condition under the letter of credit, it must be signed. But we found that it was signed by an authorized person. Mr. Evazov is the only sole representative of Manifesto Ltd. And it's not his signature, obviously, on the act of acceptance.
The claimant is saying that the stamp would count as a signature.
No.
I understand correctly.
Well, it's a reasonable practice to believe that if one party signs a document and puts a stamp, so the other party must do the same. Otherwise, there is a place for a signature. There is a place for a stamp from both sides. Paragraph A20 of the International Standards of Banking Practice states that documents, quote, presented are issued by any formal signs according to paragraph 20. This formal sign is the signature, but not the stamp. Paragraph A27 operates with term originality. So the bank should verify whether the signature is original. And it comes contrary to the arguments of the claimant that we have no right to examine the signature or stamp or so on. We must do it in order to prevent bad faith or income. So other documents of the letter of credit were not presented properly. Let me draw your attention to the list of the documents on page 20. A statement in the form of annex signed by an authorized representative of beneficiary. And an example of the annex in case material, page 23, is slightly different from the one sent by the claimant on the page 24. It has some additional information, but that comes contrary to strict compliance principle according to ICC 600. A notarized copy of shipbuilding contract. There is no evidence in the case that a notarized copy is submitted by the claimant. The one that is in the case file, the case problem, does not have any stamps of notary. We don't have problems with invoice of the beneficiary, a certificate of quality, and certificate of origin. I've already proved you that the act of acceptance has not been presented properly. And the National Passenger Ship Safety Certificate was also missing. That's why, and the claimant did not prove that he didn't need to, the burden of proof was not fulfilled by the claimant.
The question about notarized copy of the shipbuilding contract.
Yes.
Why didn't you raise it in the letter to the claimant?
Because it was a short analysis, we were running out of time. We have only 5 days. We didn't see it as a major discrepancy. Two major discrepancies: that one document is not signed properly, the other one is missing. So, but when they filed the claim, we of course examined them with very strictly.
Can I add one argument to the fact that we didn't mention the discrepancies in the letter? I think we need to notice that we have made it like a bifactual action. For example, we were enclosing these all documents, and the buyer, so the Mr. Evazov and our applicant in the letter of credit can see that the act of acceptance isn't signed and that there is no ship safety certificate. So yes, we didn't mention these discrepancies in the body of the letter, but we enclosed in the document, and it is it must be obvious for our applicant, for the buyer, that some of these documents are not in compliance with what we need.
I think I find it difficult to follow this argument, because if you are enclosing something but saying nothing, how would they know that you disagree with something?
Well, nevertheless, on the 8th of March, he proved that we should not.
He was analyzing, so it was like proved by the factors that by analyzing the document. So he made for us a conclusion that some of them are not in compliance with the requirements.
And also the argument of the claimant that we didn't decide what to do with the documents doesn't mean that we should elaborate on the discrepancies. We did send you documents, otherwise how would they be in this case problem, in the materials of presenting?
If, just purely for the sake of argument, if you did not inform the buyer about the discrepancies, what would be the consequences which would flow from that?
Well, according to UCP 600, the bank, if it fails to distinguish the presenting of the documents as proper, might refuse. We were trying to cooperate with the
They
claimant.
may refuse, you said.
We may refuse, yes. We may refuse for payment.
So, regardless of whether or not you inform the buyer of discrepancies,
Regardless of,
you would still be entitled to refuse payment.
yes, I'm just
Because we
trying.
didn't find
Yes,
them.
when the nominated bank acting on its nomination and confirming bank if any of the issuing bank determines that the presentation does not comply, it may refuse to honor or negotiate. But on the other hand, we can, according to paragraph 16b, we can contact a buyer. So we were thinking that Mr. Avazov will say that everything with the documents is okay, so we can effect payment. We were not acting in bad faith. We were not trying to.
Again,
We
we
were
said,
trying not to pay. Yes.
yes, we're just trying to conduct due to the business practice with a good faith. So, seeing that there is no ship safety certificate, we just wanted to inform our buyer maybe we can do it without these documents. So it was just our enforced to make a payment, just to conduct
Yes,
in
and
a
they
good
should
faith.
be thankful, and instead of this, they're suing us.
Do you agree with the claimant that any sort of public policy concerns or objectives with respect to fraud are not relevant to these proceedings?
Sure we do, but we are not saying that we think that the act of acceptance is fraud. We're just saying that it's not properly presented.
We're just looking at documents.
And the presentation did not comply with the strict compliance principles of UCP 600.
One question about notarized or unauthorized copy. In your letter to Mr. Ayvazov, page 29, you provided a list of enclosed documents, and the second point is notarized copy of ship dues and contract. So how can you comment it in connection with your argument that
Must be a
enforcement?
mistake, but I don't know. We'll kill our secretary who wrote this letter. We don't know. No notarized copy. We didn't see any.
I think it was a technical mistake,
Yes.
unfortunately.
So,
May I
Please.
proceed, please? So, all the above-mentioned facts show that the presentation on the 7th of March was not proper, and all the claims of analogous acts should be rejected. Besides, no monetary evaluation of the interest or the cost of this arbitration is not mentioned by the claimant. But according to the Article 4 of ICC Rules 2012, the claimant should provide monetary evaluation of the expenses that they're trying to sue for us. So on the basis of the above, the respondent respectfully requests the arbitral tribunal to find that it lacks jurisdiction over the claims submitted by the claimant in the present arbitration. The ICC Court of International Arbitration to suspend the proceedings until the award of ICC case number 1998. The arbitral tribunal, once it is constituted, to suspend the proceeding until the award of ICC case 1998. The arbitral tribunal to reject all claims of the claimant entirely on the merit. And the arbitral tribunal to order the claimant to reimburse the respondent all costs related to this arbitration. I would like to close my session. Thank you.
One question about evidence. As a evidence of wrong signature of Mr. Ayvazov, you provided a copy of allegedly his credit card. Do you think this evidence is reliable enough for tribunal to believe that this is really his signature? Do you think that maybe another, maybe better evidence to persuade the tribunal?
Yes, the one on the shipbuilding contract.
It is not in compliance with that we have seen on there are two, and to understand that one person can't have two different signatures. It's like
Especially
contrary to
for
common
legal
sense,
documents.
especially for legal documents. It's the other one.
But the CPs there are several good points that we would like to submit to tribunal. The first concerns the principles of strict compliance. It's one of the core principles of the letter of credit, and it bounds not only the claimant with regard to the presented documents, but also the respondent with regard to its notification. And as far as the respondent did not comply with its requirements under the letter of credit, and the UCP 600 clearly established that such behavior waives the opportunity of the bank to apply to any discrepancies. All the arguments supported by the respondent with regard to discrepancies must be found inadmissible in the present dispute. Second issue is the Acceptance Act and the signature. We admit that these signatures may look different, but as it is stated in the UCP 600, the data must not be identical to, but must not conflict. Well, we agree with the fact that the signature is not identical, but is there any conflict between this data? Whenever a person signs any document, this person's signatures are always in this or that manner are in conflict, because we are not robots after all. We all always we sign differently in any way. And
I
it
must
was
say here the difference is
yes,
too
but
significant.
after all, it was not the bank's scope of examination, and it was not the bank's power to establish the, as to say, percentage of this discrepancy.
So just, if I can just follow up on that point. If I sign a document, and I sign the document as John Landrew, do you say that's not a conflict? Where my name is George Landrew?
It depends on the point of view that I'm looking at this one. If I were a bank, that would not matter for me, because the only requirements that I should apply is the requirements for using this. And with that matter, these requirements are violated in no way. So this is why we should treat this in that way. Also, with regard to the fact that the claimant sent a letter to the buyer disclosing the documents that the respondent stated that it was some kind of act of politeness, but it clearly violates the principles of autonomous examination of documents. The bank did not identify any discrepancies that it found after examination of these documents, but however, it sent the list of the documents to the buyer, and taking into account the fact that the bank has been the buyer's bank for 7 years, we may assume that there are special relations between these two entities, and it may not be considered just to be an act of politeness. By doing this, the bank clearly violated its obligations under the UCP, and we presume that it somehow asked the buyer for instructions in order what to do with these documents. We will raise no question if in that letter there will be some discrepancies listed, but however there are none. So,
And what are the consequences of this violation of UCP 600? Assuming that you're right, what's the consequence?
well, we believe that UCP should not be applied partly. It should be applied as a general document. And we see that the respondent in one part when it's beneficial for the respondent, it applies the requirements of UCP. But in other parts, it waives its obligations. It states that the respondent should not comply with this obligation. And according to the general principle that no one can benefit from its own wrong acts, we state that the UCP may not be used as a means of justification of unlawful refusal to pay on the letters of credit. It should be used to establish strict rules between the bank and, in our case, the claimant. And these rules were not followed by the bank, so the bank cannot apply to these rules to justify this wrongful act.
So by breaching UCP 600, you're saying then they're required to pay under UCP 600?
Can I ask you to repeat the question?
Are you saying that by the fact of the matter that they breached UCP 600, they are then required to pay under UCP 600?
Not due to mere presence of this fact, just after examination of all the issues that were concerned in the present GSP. There is an obligation to the bank to pay. It doesn't mean that...
regardless of UCP
yeah,
600?
yeah. But taking into consideration the UCP 600, but not only this document.
Okay, that's clear, thank you. Please continue, I didn't get to.
I guess that's all from my end.
Well, we've just now had the, so you now have the last rebuttal, is that right? Yes, please.
The claimant says that the autonomous examination principle, but where does it come from? We don't know such principle. We expect examination. We were allowed, according to the terms of UCP 600, to approach our client, Mr. Evazov, to eliminate discrepancies as we thought. But it didn't happen so. Hadn't we approached our client, we would have still refused the payment. And this fact doesn't show anything. Special relations between Mr. Evazov and Trust Me Monk are not proven by the claimant. So the claimant also said that when UCP 600 favors us, we apply it. When it's not, we do not. But it says some parts of it, but we apply it as whole. We do not take just one part. He doesn't show. The claimant doesn't show what part we apply when it's applicable for us, when it favors us, when it benefits us. We show in these proceedings that step by step, we, with reference to UCP 600, with reference to International Standards of Banking Practice, presentation of 7th of March, the documents was not proper, and the claimant was lawfully refused for payment. Yes.
I want to notice one thing that is, I think, also important for us. The claimant was in contrary with the arguments. First of all, in the procedural part, the claimant said to us that the respondent is a triangle contract, and the respondent also is for respondent to the arbitration clause and the many things that is included in the shipbuilding code also extended to the respondents. So by this fact, the claimant said to us that there is some connection between the letter of credit and the shipbuilding contract, and due to this, they made a conclusion that we need to be covered by the arbitration clause. But now, in this substantive part, the claimant said to us that the letter of credit is an autonomous character and it is independent. It is the contrary arguments, and there is a contradiction. And also I want to say about our right to examination, to examine the documents. The claimants say that there is no identical, but there is no requirements to make the identical signature, but it must not to be in contrary. But as we see on the act of acceptance that there is another name, there is another surname, Okay, if for example there is another surname and there is some mistake with letters or some mistake with some signs, but there is another name, there is another surname, I think it's not a 50%, it's not identical and it is in contrary to the signature.
I assume I cannot speak to comment.
I think you're out of time, I think. But I have no doubt that you have many things. So I think that then wraps things up, right? So I wanted to, before we end this, I wanted to ask both parties if you consider that you've had a fair hearing today, and if you have any concerns at all.
No, we don't. Fair hearing, no concerns.
Very good to hear that. Thank you. Thank you. Yeah, I think what we were going to do is as you know, as we've been informed, is at this stage we don't fill out a score sheet and we will consult, and it's just a question of which side will prevail over the other in terms of the performance. If you would like, and I think we would be happy to give some feedback, if you consider that would be helpful.